Someone had some background noise.
We can listen to you, Juliano.
Então,
Agora melhorou.
ok. Bom dia a todos e todas. Vamos então iniciar nossa live de hoje. A gente tem um convidado que é o Dirk e traz um tema muito interessante, que é o papel das cortes no judiciário, no delineamento das regras e da regulação no ambiente digital. É um ponto importante, porque às vezes nós não prestamos atenção e olhamos muito apenas só a legislação, e é um tema muito atual e pertinente, especialmente para o Brasil, quando nós pensamos em todo o debate acerca da regulação, tanto do conteúdo nas plataformas, quanto dos mercados digitais. No conteúdo das plataformas, nós tivemos recentemente a decisão do Supremo. I'm going to shift to English. Okay, sorry, forgot about it. So it's a really timely debate for Brazil, considering that we have the recent decision by the Brazilian Supreme Court shaping rules also about the content moderation. And also we have this proposed regulation by the Minister of Finance and the Minister of Justice that is expected to be launched in a few days or weeks, and which is the object of a great debate and a very polemic debate related to tariffs that are imposed by Trump regarding international commerce, and they are focused, one of the arguments is based on passing legislation. But at the same time, there is already rules being applied by the courts regarding this decision by the Brazilian Supreme Court. So, and maybe a legislation on that would bring legal certainty and would even possibly relieve the obligations that were defined by the Supreme Court. So this brings a different scenario where legislation may bring legal certainty, and it's probably better to have legislation than having some decisions by the courts. So my audio is not working properly, so I have made just this introduction, and we will leave the floor for Bianca Mollicone and try to be more silent today, even though I know that Dirk will bring many interesting and provoking questions. So I will write my questions to Bianca, and then she may propose them to Dirk. Bianca, floor is yours.
Good morning, everybody. Dirk, it's a pleasure to have you here. I will make a presentation of Dirk. Dirk is currently Director of Competition Policy at the International Center of Law in Economics. His work focuses on the law and economics of antitrust, with an emphasis on innovation, policy, digital markets, and European competition law. He's also an adjunct professor at Liège, University of Liège in Belgium, where he teaches courses on competition law and the economics of antitrust. And Dick is studying digital markets since a long time. He has a lot of articles. And today we are focusing on his recent article about, as Juliano says, the effect of this of jurisdictions and of also regulatory bodies on the regulation of internet, a silent regulation of internet. The floor is yours, Dick. It's a pleasure to have you with us today.
Thank you very much, Bianca. It's really nice to be here today. So the topic I wanted to talk about today, I think, has been prompted by pieces I wrote in Jota and in Reason magazine. And both pieces sort of start with the same question, which is, well, if I were to ask someone, say, on the street, who do you think is designing the online services that you're using today? I think the response that everyone would give, well, it's a Silicon Valley engineer, a product designer, finance people in, venture VC finance people in San Francisco. The reality is that if that was true before, there is an increasing shift towards courts and regulators designing how online services function. And so I'm going to talk a little bit about that, what's happening and what it means for consumers and whether it's a good idea or a bad idea. So the starting point is that if I look at today's biggest online services and how they sort of are designed or how they were initially designed, they were really shaped by market forces. So the government didn't tell Google to introduce temporary links. The government didn't tell Amazon to invent the buy box, or it didn't tell Apple, oh, it would be a great idea if you created an app store. These features they emerged from competitive forces, and they proved very successful. What we see today is several legal battles and pieces of regulation trying to reshape these very basic features of the services we have come to become familiar with on the internet. So, for example, you see regulators more and more often, and courts, deciding, well, how can an online firm monetize its services? How should content be displayed on what we might call gatekeeper or core platform services? Similarly, we see courts increasingly saying, well, what two components of a service can be rolled into a single product offering? So I can give a couple of examples of this to make it a little bit more tangible. For example, in the United States, there's litigation being brought by Epic Games against Apple that would essentially essentially force Apple to display in-app links to outside payment services. Apple has refused to do this, at least it says, because of safety issues. There's clearly a risk if someone is using an app, you display a payment link, it's not vetted by Apple, you could be taken to an outside site that is not reliable. We can debate whether that's Apple's assessment is right or wrong, but there are clear safety implications involved. Similarly, in the United States, there's litigation brought by the DOJ against Google, taking issue with the way in which it pays to place Google products, Google search, as the default search engine on iPhones, amongst other things. Again, we can debate the pros and cons of this arrangement, but we should at least recognize that there are risks involved. This is sort of an arrangement that has emerged through market forces. It has tangible benefits for consumers. If Google is paying Apple to display the Google search bar, that payment can then be used to subsidize device sales to consumers. And an iPhone is not a cheap device. If you're getting that for cheaper, it's generally seen as a good thing. There are analogous cases being brought against Meta and Amazon, for example. So one case in the United States could potentially undo how Meta has created this ecosystem that combines Facebook, WhatsApp, and Instagram. This could potentially be a very valuable feature because data from one service can be used to improve advertising on another service, which in turn means that consumers can have potentially fewer ads displayed, more effective ads displayed. And we should remember that the alternative to targeted ads is non-targeted ads, which consumers may not enjoy, or even a paid tier, which again has implications for consumer welfare. Similar story with Amazon in the United States, where Amazon it doesn't have a completely closed logistics network, but a government suit is trying to open up that logistics network, make sure that Amazon, more often than is the case now, offers third parties the opportunity to do logistics for the sales that it's making. And similarly, governments taking issue with the Prime service. These are just a couple of examples. I think what's potentially more important is that it's not just an American thing. We see this theme playing out across the globe. Perhaps the highest profile example is what's happening in Europe with the Digital Markets Act. And there we see the same thing. Like, we see the European Commission redesigning, for example, how Google search can display map links in a search engine. And so now in Europe, you cannot, if I search for, say, a restaurant in Brussels on Google search, I cannot directly click on the map icon in my search results. And that is decided, it's designed by the European Commission. Similarly, we see the Commission trying to open Apple's ecosystem by allowing third-party app stores. We see the Commission taking issue with Meta's personalized advertising model and requiring that Meta offer a non-personalized advertising alternative. It's not just a European thing either. Bills under, this is relevant to your audience probably, but it seems that in the next couple of days, weeks, a similar bill to the Digital Markets Act will be introduced in Brazil and would have very much the same objectives of redesigning online platforms to make them more open. All of this would be fine if consumers were perfectly happy with these changes. But what we see from what's unfolding in Europe is that things are not necessarily going according to plan. So I think there are three main consequences to what's happening. The first is that certain services are becoming degraded as a result of attempts to open them. The most obvious example is probably the Google Maps example that I mentioned, where it's completely counterintuitive when the market has settled on this very practical feature of searching for a place in a search engine and being able to directly click and go to a map. Trying to undo that via regulation is just, I think, going against pretty clear revealed preferences from consumers. So that's number one. Number two, what we also see is that as a result of these regulations and court orders, we're getting delayed product launches. So at this point, rather systematically, Europeans will get, for example, generative AI services a little bit later. Examples included Meta's Llama generative AI, OpenAI services also deployed later in Europe. Another example, which isn't AI, is Meta's Threads application or online service, which was again deployed much later in Europe than in other jurisdictions. A third thing, and it's becoming increasingly salient, especially with news from Donald Trump last week, is that this regulation, largely of American firms, is fueling trade-related tensions, where we had a Biden administration a couple of years ago that was fairly passive in trying to protect the interests of American firms abroad, we now have a Trump administration that, rightly or wrongly, is much more aggressive in this sort of protection of American firms. Some of it is a little bit hypocritical because, as I started this case with the US as an example, where actually the US is bringing cases that are quite similar to what you see in Europe under the DMA and in other jurisdictions, they're just bringing those cases under normal antitrust law before general courts. But there is some hypocrisy in saying, well, Europe, what's good for us is not good for Europe. However, there is also an element, I think, that is correct in the Trump approach, which is if you look at something like the Digital Markets Act in Europe, it is designed to target almost exclusively American firms, and it is designed to hinder the competitive position of those firms. So I can see sort of why a US administration would take issue with that. Either way, these are sort of emerging consequences of these regulations that may not be ideal. I just want to sort of finish with one important point, which is, well, why do we see courts and regulators doing this? And I think one way of summarizing it is there is a belief underpinning these initiatives that more open online services are necessarily better for consumers. So by more open, I mean an online service that interoperates better with complementary services. That's better for consumers. The idea would be, well, how can a consumer be worse off if they can now choose between Apple's App Store and the rival App Store? The problem is that this sort of belief, it doesn't match the reality and the history of online services. So what we see is that time and time again in the formative years of online services, consumers don't necessarily opt for the most open alternative. So some examples are Apple's iOS is arguably a much more closed ecosystem, for example, than Google Android or others that competed in that marketplace. Yet consumers actually valued this closedness because it meant security and ease of use. Another salient example is, if people remember, in the desktop era, there was an open operating, there still is, an open operating system called Linux. And Linux was free. It was very, very reliable in many aspects, but consumers did not choose to install Linux. And we should ask why. Like, if consumers love open ecosystems so much, why did they opt for the proprietary and closed Microsoft Windows rather than the open Linux? And we can go into the reasons later, but I think part of the answer is just that there's a trade-off between open and closed ecosystems. And part of it is that an open ecosystem may not be as easy to use. We had, there are other examples that we could go through. Amazon was arguably more closed than eBay, that it outcompeted. And now in the generative AI world, we see sort of the same pattern repeating, where OpenAI, for example, is arguably a much more closed service than something like Meta's Llama. Yet for the moment, it seems to be OpenAI's ChatGPT that is outperforming the more open Llama AI. So this doesn't mean that that closed is necessarily better. What it means is that there's a trade-off between openness and closedness, and we shouldn't assume that opening every service is good for consumers. Instead, what would be ideal is for markets to make the determination of where a service needs to be open and interact with rivals, and where it needs to be closed, for example, to preserve user security and ease of use. That sort of leads us to the topic of today, which is I don't think that this insight is properly understood by many courts and regulators today. And the risk is that courts and regulators are no longer just deciding cases in the online world, but imposing remedies that go against the sort of the natural features of a market and try and impose this sort of vision of more open is better. And I don't think that that's ideal for consumers. Yeah. We can go into more detail.
Great, Dirk. It's very good. I would like to begin with a question that in your article, you highlight the dangers of courts and regulators being this architect of digital platforms. And this perspective, it resonates with David T's theory of dynamic capabilities, as well as Schumpeter evolutionary economics, both of which stress the successful strategies emerge through market-driven selection process rather than top-down design. In this perspective, current antitrust intervention as risking a substitution of the market's evolutionary mechanism with judicial or regulatory mandates that may ultimately harm consumer welfare, as you very precisely pointed. Building on your point that judicial and regulatory interventions risk this disrupting evolutionary process described by Tish and Schumpeter, how should policymakers distinguish between intervention that genuinely foster dynamic competition and those that merely freeze existing structures? For example, as you said, and you brought a lot of examples in Europe and in the United States, in the recent case of Google's, Mozilla's claim that Firefox could collapse without Google's financial support. Is there a risk that these well-intentioned remedies might inadvertently reduce diversity in the browser market and consolidated power rather than disperse this?
Yeah. I think there's probably the part of the answer is, at least I think, that regulators and courts need to have sort of a, I don't know, Chesterton's fence type approach to online platforms, which is don't start off on the assumption that whatever behavior you see is necessarily anti-competitive, detrimental, and has no role. We should start under a humble position of, well, let's try and understand how these online markets work, how these services are funded, how their business runs. And from there, try and have, if you need to intervene, try and have a light touch intervention that preserves key features of the service. So in your example with Firefox, I think it's what it goes to is the Google owns the Chrome browser, but as I understand it, the Chrome browser is itself built on an open source project called Chromium that is very important for other browsers. With the Chrome browser, Google has incentives to be an active party in Chromium. If as a result of a court decision, we break off Google Chrome or Google's Chrome-related activities for the rest of Google, there's going to be a question of, well, what is Google going to do to monetize that Chrome-related activity, right? The way Chrome works now is it feeds into the broader Google ecosystem that is funded by advertising. It's very unlikely that by breaking off Chrome, we could recreate a sort of second parallel Google advertising ecosystem. And so there is a real risk that with a Chrome-related breakup, the ecosystem collapses and consumers, at least in the short to medium term, are left significantly worse off. Again, I think that goes in the direction of, well, courts need to really, one, try and understand these online ecosystems as best they can, and two, use light touch approaches as much as possible, because the bigger the intervention, the higher the likelihood that you break something that's important.
It's interesting, Dirk, because the first decision in Apple Epic Games, in the case in the United States, the judge actually only give reason to Epic in one point in USL competition law. Competition law in California. But then in April this year, in April 30 this year, the second decision about the compliance with the first decision, the judge just make a move to a rather different direction, because it accuses Apple of elusive compliance. So it brings us the difficult in really see how can these platforms comply with the decisions. You see that it's a very thin line, because the decision was quite good for Apple at the first decision. The court has confirmed the decision. The Scottos doesn't appreciate the court decision. Then when the court was looking at the compliance of Apple's of the first decision, then it turned it totally the direction, and then it asked Apple not to charge for the service. It even if it's not in Apple Store, but it can charge for anything. So how do you see this balance in the compliance of these decisions, the judicial decisions?
I mean, there's many that it's a big question. I think there are many areas in which courts can try and find remedies that are more light touch, try and impose decisions that are less likely to break an online ecosystem. So, for example, in the sort of cases being brought by Epic against Apple and Google, I think one of the underappreciated ideas is the following. If Epic brings a case against Apple or Google before courts, and Epic wins that case, that's at least for now the case in Google, and in Apple it's mostly Epic loses, but actually it does win on California unfair competition law, and that does give rise to a remedy. What we've seen courts doing quite often is imposing remedies upon players like Google or Apple that apply to all online services, all app developers. That doesn't have to be the case. If you're the court, you have a dispute between Epic and Apple, you can impose a remedy that applies only to those two companies. One of the advantages of that is that immediately you give, if the plaintiff has indeed been harmed, you give the plaintiff the reparation that it arguably needs. And on the other hand, you don't have these sort of ecosystem-wide risks because you're applying a much more targeted remedy. This is just one example where courts can modulate remedies to be, other things equal, less likely to harm consumers. I think there are more, things along this path. There's a sort of traditional competition or antitrust distinction, which is we understand that the result of many antitrust decisions or regulations is going to be something where a firm is required to give access to another firm. And it's been generally understood that these sort of access remedies, one, should be used sparingly because it's quite onerous on a platform to be forced to open up your service to, anyone who seeks access. And second, we should be a little bit careful because there's sort of a slippery slope where these remedies almost inevitably give rise to price regulation. And the history of price regulation is not great. And so courts for a long time have sought to avoid price regulation as a remedy. What we see happening in these online markets is courts and regulators forgetting these lessons, opting very quickly for very broad access remedies. Like you can look at the European DMA that imposes all sorts of interoperability requirements on a firm like Apple, for example, and not shying away from price regulation. So not just requiring access, but saying, well, look, the access that you provide is going to have to be under pricing terms that we are going to control because we want to make sure that rivals survive. But again, when you're a regulator and you sort of enter this position of I'm going to choose the price and I'm going to make sure that rivals survive, you really have diminished the free play of competitive forces. And I think that you again fall in this risk of becoming a designer rather than just a judge, adjudicator.
Great, and I think this will be the greatest debate because, as Tiroli said, it's very difficult for a regulator to know exactly what should be this tariff of access. Yeah. And it's a problem in the United States, in Europe now with DMA. In Brazil, we have an Apple case that it's not on this point yet, but this matter will arise at any moment about the value of the tax, as it's arriving in other discussions, as in SEPs, because you have to have friend tariffs. So what is friend actually? Exactly. Well, Juliano wants to make a question. I'm gonna read his question now because his microphone is not so good today. So in your paper and also in the introduction, you suggest that the proper way to design the online service is through market forces, and court decisions may be threatening successful business models. So in principle, legislation would also not be commendable. But law courts and administrative decisions being at place, would legislation be desirable to bring at least legal certainty, but maybe also fix some decisions compromising the market? What do you think about this?
I'm not categorically opposed to legislation. I am worried about the legislative initiatives that we see now, because I think many of them aren't brought about by a desire to clarify or to enhance existing rules. A lot of them are motivated by a real desire to take the internet, or that takes the internet as it is today as failing, and that want to reshape that into an idealized internet that doesn't exist. I think that's a worry. So I'll give an example. The European DMA is, in my opinion, largely that. It takes theories of harm that exist under European competition law. It's not as much about clarifying those theories of harm. It's about saying, once and for all, we have decided that self-preferencing is harmful. We have decided that using data across different services is more likely than not to be harmful. And we want the internet to be shaped based on these axioms. The problem is that the reason why there was uncertainty in court cases is because the axioms that I've just mentioned, like self-preferencing bad, data sharing across silos bad, there's no real evidence to suggest that these things are always bad. And so what regulators are essentially doing is sidestepping evidence-based safeguards that exist in competition law, so that they can design platforms as they desire. And I think that's the wrong way to proceed. Sort of in a perfect world, you could have a commission say, look, right now there is uncertainty about how European competition law regulates certain conduct. And for example, you could have that in the United States, where Epic has cases against both Google and Apple, and they're in front of the same sort of circuit court, and the outcomes are completely different. So I can understand the argument that there's maybe a need for, or that in a perfect world we'd like antitrust law, competition law to be a little bit clearer. But it's not the same thing to say, okay, we'll have a dispassionate approach. We'll see where there's uncertainty, for example, with regard to market definition, and we'll try and identify how market definition should be done in the online world. And we'll make sure that there are still evidence-based requirements to ensure that market definition is done properly. You could do all of that via legislation. It may not be the perfect tool, but it's possible. I don't think that's what's happening right now. It's not a sort of dispassionate, evidence-based assessment that leads to these regulations. It's a desire on the part of enforcers to impose their vision of how online markets should function. And I think that's a mistake.
Great. Now, Cesar wants to make a question.
Hi, Dirk. We have in Brazil just changed the direction. We have in Brazil, the Supreme Court has challenged the Article 19. I think you are aware of it. This article provided for freedom of the networks, the big techs were not held responsible for any content that could bring damage or hate speech, whatever, if it was not the focus, it was not that there was not a court decision before it. That's what the Article 19 has stated. The Supreme Court just challenges this and said, well, you have to anticipate. You don't need to have this court decision before you withdraw contents from internet. So now, some sense, and it's not clear at all, the networks supposed to withdraw these contents. And what do you think about the judicial uncertainty that can be brought because of this sort of procedure that is not very clear? Because the companies have to decide what is bad or what's wrong from the legal point of view, rate speech, whatever, the things that are really very subjective at all.
Yeah, it's a big topic, right? And if it was easy to make these moderation decisions, we know that by now. The problem is that content moderation is extremely complicated. So I'm less familiar with the Brazilian context, but I think there are many sort of starting points that everyone can accept. No, I don't think anyone, or almost no one, is claiming that there should be no moderation at all on the internet. I think that it's fair that some things are going to have to be moderated online because even as a consumer, there's some things I don't want to see. The question is who does that moderation and with what kind of rules. That becomes really complicated. I think a second sort of important point in the debate is right now there is a lot of competition online for publishing content. For me, when you see markets with intense competition, other things equal, it significantly increases the likelihood that, for example, content moderation decisions are going to be done in the best interest of consumers. And I have yet to hear an argument that I find convincing that there's sort of a market failure for content moderation where, despite competition, content moderation is going to be done badly. I mean, we could go into more detail. So I think the starting point definitely doesn't, to me, indicate a situation where the government should be sort of taking a hands-on approach to content moderation. I think that we just have this competition that is going to deliver on content moderation. It may not be perfect, but in all likelihood, it's going to be better than what a government with informational limitations is going to be able to do. I don't know the Brazilian context super specifically, as I said, but I do know in Europe that for a long time we had what's called the e-commerce directive. That was sort of the main legal text driving content moderation online. And essentially it was, again, it's not my main area of expertise, but it was something along the lines of, well, platforms, you are immune from liability so long as you comply with certain limited things, which is, for example, for clearly illegal content, if you're made aware of it, you have to take it down, which, we can debate on the margins, but it seems relatively reasonable. We've now moved in Europe with the Digital Services Act to a much more, to a world where the government is much more involved in content moderation, looking at much more granular things that the platform does. For the reasons I suggested, I don't think that is likely to make consumers better off, because markets are very, very good when you have competition at sort of aggregating user preferences and figuring out what consumers want. And I don't think that governments have the same incentives and ability to do that. This is all a long way of saying I'm not an expert, but I don't think that increasing platform liability and giving courts a heavier hand in content moderation is a great idea.
Dirk, on the other hand, the fact is, the big techs are actually, they already make some content moderation, and sometimes you are out of the network and you don't know why, and you don't have procedures to know what happened, or to challenge, or try to perhaps to challenge this. Do you think it was a good idea to put some procedures for them to do something about this?
Yeah, I'm not. So again, I will confess my ignorance of the specifics, because that's sort of important. But at the margin, I by far prefer a requirement that, for example, if a user is deplatformed, there should be that user can have some recourse, at least to understand the reasons and contest the reasons. Like, I'll frame it differently. One requirement, if you come to deplatform, it could be, well, we don't decide when a service can deplatform a user. That's up to the service. But when it does so, it should have a reason, and the user should be able to ensure that the facts match the reason that's stated, right? Those are two different things. And my approach will always be, well, start with the less interventionist one, which in this case would be something like the transparency and create an appeal procedure requirement that you mentioned. I would be much more reluctant to go a step further and tell platforms, you cannot now deplatform people because of their political views. I think that is going a step further, and I'm not sure that is necessary at this point. Again, this view is sort of based on my perception that there's still quite a lot of competition online. So if I want to express my views online, I can go on LinkedIn, I can go on Twitter, I can go on Facebook, I can go on Instagram, I can go, I can be listed on Google search, you name it. And so as long as there's that competition, I think that platforms are going to compete to try and find the right balance between over moderation and under moderation. And you sort of see that playing out. Like I use Twitter X, and X has clearly made the decision to be on the less moderation side of the debate, or at least less moderation for certain political ideas. That it's not perfect. It's never perfect. The question is whether regulators can do better.
Dirk, although much of the prevailing doctrine in economic literature conceives of data as non-rigorous and non-excludable, do you believe that some form of structured of data sharing could be desirable at this stage to foster competition, for instance, through mechanisms such as data trusts or data licensing arrangements, or even like Tim Berners-Lee's SOLID project?
So it's a complicated question. There are sort of like with all of these things, there are trade-offs. I think that the first, for me, the starting point of the debate is something like this. Right now, I am not convinced that incumbents have a competitive advantage by virtue of their data. And what I mean by that is a lot of these initiatives are sort of along the lines of, well, we should force Google, Amazon, Meta to share the data they have, because otherwise they will sort of perpetuate the lead they have in their current markets in new areas like generative AI. If you look at generative AI, it doesn't seem to be, for the moment, and of course it could change, but for the moment, it doesn't seem to be the Meta, Google, Amazons, Apples of this world that are leading in generative AI, even though generative AI is extremely reliant on data and is sort of the example that people had picked out to say, well, small firms will not be able to compete here. What we do see in generative AI is firms there's so much publicly available data. There is arguably a case to be made that how you use data is much more important than the data you actually have. There's a question of, well, you compete on efficient training, the sort of DeepSeek example was along those lines of, well, you can compete along many dimensions, and apparently the dimension along which they competed wasn't, more data. It was just find a better and more efficient way to train your AI. And so all of this is just to say, I'm not sure right now that data and access to data is all of that important, or maybe to be a little bit more precise, I don't think that allowing startups to access the data of incumbents would meaningfully change the competitive landscape. And so I don't necessarily see a need to enforce this sort of data sharing, which bears risks. Because as soon as we say, we could just take an example like Facebook. If we tell Facebook to share data, a lot of the data that Facebook has is personal data. And I feel reasonably confident that my data is in relatively safe hands with Meta. If I force Meta to share that data with anyone, that confidence erodes for me. And the sort of Cambridge Analytica story is kind of about that. It is about a third party that isn't Meta behaving in ways with user data that don't align with how Meta would like them to behave. So I do have some trepidation about data sharing, or mandated data sharing.
Great. I have one last question, and one last question from Juliano. Do you think that isn't the case that the market itself will eventually change the business models of digital platforms, making ex-ante regulation legislation not only confusing but also quickly obsolete? Because, for example, the rise of AI models such as ChatGPT has already transformed the way people search online, and even Google is adopting AI, which could fundamentally alter how its search engine is monetized, since users who look at the AI-generated answers often no longer look at the traditional search results that's the actual monetizing model of Google today. So it's very quick. I would like to listen to you about this.
No, I think that's right for many reasons, and I just list a couple. We mentioned Google search. You're right. The search market could be about to change in ways that are difficult to understand, and Google's competitive position might not be what it is today. Yet the rules will still remain. One risk is that we sort of see this happening. The DMA is based on this assumption that for the most part, online services can be made to interoperate. So, the basic idea is like, well, Google search can be opened up to rival price comparison services or to rival map services. But we now have generative AI, and I'm not sure that applies. It doesn't seem obvious to me that you could integrate any generative AI into Google search very easily. I don't think we have that technical solution right now. And so a ban on self-preferencing with respect to generative AI for Google is essentially saying not Google, you need to open your search engine to many generative AIs. It's really saying in practice, Google, your search engine cannot be combined with generative AI because it cannot be made to work in an open fashion. So I think that's a huge risk, because it essentially goes to what you're saying, like a service evolves and we lock in a previous design because in this sort of new paradigm, we can't do interoperability well. So I think that's absolutely a risk. And I don't see, in my mind, sufficient safeguards in instruments like the DMA to ensure that they stay relevant on an ongoing basis, and that they don't sort of lock in old designs and prevent sort of iteration.
Dirk, in some sense, what you said, in some sense, if you forbid self-preferencing in some cases like Google search, you're just forbidding how to monetize Google at all. Is that true?
Yeah, I think it to a large extent it can go to that. I don't know that anyone has these numbers, But it's very clear that when the European Court of Justice banned Google's self-preferencing with respect to price comparison services, it was quite literally going against Google's monetization choices. Right? The reason Google created the shopping box is not that it had this great desire to be a price comparison service. It's because Google understood that price comparison is a very valuable place to advertise. And Google Shopping was essentially an advertisement-based service. And when you say to Google, well, you can't self-preference anymore with respect to shopping, you exactly what you said. You are essentially saying that their chosen monetization is not acceptable and that they should revert to their old monetization, which is just ads based on your search, or very just sort of the same type of ad regardless of the type of search. And I think that's a shame.
Great. Juliano has his last question here about artificial intelligence. So do you think that artificial intelligence be effectively governed through market forces alone, or that for artificial intelligence we should have any kind of regulation, because it involves a bunch of fundamental rights that can be, surpassed?
So I think to me, the starting point is that no product is ever completely unregulated. Like sometimes I've heard Margaret Vestager, who is the previous European Competition Commissioner, talk about the online world and say, oh, it's the Wild West. But it's not the Wild West. Existing laws, liability, they apply in the online world like they apply in the physical world. And so it's not like this is sort of a frontier where there's no regulation. Now, the question is whether, compared to the regulatory baseline and the legal baseline that we have today, artificial intelligence requires sort of an added layer of regulation, whether there's a market failure in AI that persists despite existing rules. And I'm not sure that that's the case. Like, I understand all the concerns that people have about AI, that for example, there may be a lack of transparency as to how an AI was trained or how it gives me an answer. But there's trade-offs. Like, that's kind of been our conversation today. There's a trade-off. It could be that the AI developer doesn't really know how the AI is reaching conclusions. And if that's the case, and I'm not saying it is, I'm not an AI engineer, but if that's the case, is it worth the cost to impose on that company to essentially open the black box and try to understand it? Is it feasible? And if it's feasible, are the benefits to consumers of that increased transparency, do they outweigh the cost of actually obtaining that kind of transparency? And I don't have an obvious answer to that. At least I don't think there is a clear-cut case to be made that right now things could be better if we redesigned how generative AI works, if we made it more transparent, if we increased certain safeguards. I don't have a strong conclusion that would make things better. And the only thing that I can sort of fall back on is right now in generative AI, there are really like many competing services. Like, I think the major players, you have Anthropic Claude, OpenAI, ChatGPT, you have Meta, you have Google, and others. And so in that environment, if users really desired transparency more than anything else, there would be a very big incentive for firms to compete and offer that transparency. So, I think the balance right now is not in favor of regulation, but it could change, and maybe problems will become more salient in the future.
Great, Dirk. And to actually, we'll have almost 1 hour, and I'll just make a last question for you to comment, actually, to make a wrap up of the live, and then we have to finish. So you warn against judges and regulators playing architect of the internet. In your view, what be a healthier balance look like between legitimate antitrust enforcement and allowing platforms to evolve through market forces?
I think that the legitimate balance is something along the lines of evidence. Let's ensure that whenever we bring competition policy instruments to bear, that they're evidence-based, not assumption-based, like certain regulations like the DMA. Whenever we apply remedies, let's make sure that the remedy is, of the options open to the judge, the least interventionist. So it's like in medicine, like you'd say, well, first do no harm. Let's make sure that we apply that to remedies in online ecosystems. I think that there is a case to be made that, for example, we underuse just simple cease and desist orders as remedies. If you're a judge, you can just say, look, this behavior, it was anti-competitive. From now on, you stop this behavior with regard to the party in which you're in a dispute with. That is a very simple remedy, and it is underused right now compared to alternatives where we're trying to sort of impose market injunctions that apply to the whole market or industry. So I think it's small things like that of just evidence-based and light touch.
Do you think the MCCA will have a better look than DMA?
So DMCCA, you mean in the UK?
Yes.
I mean, I think the text to me reads a bit better and more flexible than the DMA. But ultimately, I think that you've got a common theme between all of these texts, like the DMA, the DMCC, and even legislation that's being contemplated in Brazil, which is they give regulators a huge amount of discretion. And so ultimately, the real factor that is going to determine whether outcomes are good or not is how regulators exercise their discretion. Right now, and it's still early days, I think that the CMA in the UK is a little bit more concerned about gathering as much evidence as it can, as opposed to the Commission, which is, I think, more concerned in intervening rapidly. And I prefer the CMA's sort of strategy or philosophy to enforcing its regulation. And so I think it will probably lead to better outcomes for consumers, but we'll have to see how that continues to unfold.
Yes, they're being more cautious. It's a great pace to this new legislation. So, Juliano and Cesar, do you have any other questions?
I do. I think that most of what Dirk has talked about has to do with I think that's all this regulation that's based on DMA or other access regulations come from infrastructure regulation. In that case, my question is, what regulators has missed? Because in the case of infrastructure regulation, you didn't have competition in some competitive bottlenecks, like in power transmission, you have a bottleneck. Harbors, you have a bottleneck. In the old telecom infrastructure, you have a bottleneck. The local loop. In the case of tax, you insist, and a lot of people say there is competition. There is no a bottleneck, a competitive bottleneck to make an access regulation as a traditional access regulation as you did in infrastructure. What has been missing in the case of for regulators in big techs?
I think the answer is time. So when you mention infrastructure regulation, and when I say we, I mean policymakers, have had literally a century at this point to figure out how physical networks work, what the issues are, how they should be regulated, and going through those iterations of regulations and seeing what works or not. And so, like in sort of physical infrastructure, we've had sort of this move from cost plus regulation, rate of return regulation, and sort of landing upon more modern approaches to doing that regulation, which is benchmark competition, things like that. And so there's just a lot of experience, both on the enforcement side and on the academic side, to try and understand what the problems are and what the solution should look like. The problem is that when we've moved now to regulating online services, these services are only a couple of decades old. We don't have any kind of notion of how price regulation should be done or how we should price access as a regulator in these industries. We don't have the academic background or the academic knowledge to even figure out how that should be done. And so I think there's a case to be made that it's the problem, it's a bit too early even to diagnose the problem. And when it comes to the cure, we really haven't got much of an idea of what we're going to do here. And that's not ideal. Like if I said that to my doctor, if my doctor told me, look, we don't know if you're ill or not, and we're not sure the medicine will work properly, but trust us, I wouldn't be super happy with that diagnosis. And I think many online consumers, online businesses will have that issue with online ex-ante competition regulation.
Dirk, thank you very much. It was a great morning. It was a great opportunity to debate with you, especially in this moment. While Brazil is almost having a new bill to regulate competition in digital platforms, and I hope you will be with us in other opportunities. Thank you very much to everybody, to our audience, and this live will be in our social media and also in our site of Lingual Wings Institute. And I hope all of you has a very good weekend. Bye-bye.
Thank you very much. Have a nice weekend.
I thank you, Dirk.
No, thank you. That was great.